if we also look at the report that the research department has put out on the prison reforms, one of the aspects that they have highlighted is that there are more under trials who are in jail because either the bail has not been heard, or the forensic lab has not given a report, or even if they've been granted bail, they have not been able to pay off the bail.
So therefore, you must be aware that the NALSA is doing work. We had undertaken various schemes wherever the elderly peoples were in the jail, the persons with serious ailments. A special scheme was undertaken, and under that scheme, I think we have been successful in ensuring release of many of the accused persons.
And there was also a judgment that you were party to regarding that grounds for arrest must be given to a person who's accused before they are brought before a magistrate.
Yeah,
in writing.
In writing.
Yeah, that was last of the judgments. We had to balance it because some judgments had taken a view that unless grounds of arrest are supplied, the arrest would be illegal. But we have considered some of the examples. Suppose a police officer, in the presence of a police officer, somebody kills with a revolver. Should that police officer again get a paper, write the grounds and give it to the accused, and thereafter only arrest him, and in sense permit him to flee away? So to balance the rights, we have said that the statute mandates that such an accused has to be produced before the magistrate within a particular period. And the reason for supplying grounds of arrest is that the accused must know why he is being arrested. And when a remand is sought, he should know as to on what ground his remand is sought, as to on what ground his custody is sought. So therefore, we have thought that whenever in certain circumstances the grounds of arrest cannot be supplied while arresting, they should be supplied at least 2 hours before he is arrested, so that he is aware of what are the grounds on which he is arrested. He can get the legal advice, legal help, and the lawyer would also be ready to argue the case while opposing the remand.
But there are certain cases, and I understand that arrest and detention are different things, but in the Sonam Wangchuk case, for example, and pardon me for citing a case that is ongoing, the grounds for arrest in preventive detention, the law is that you can give it later, but it was not given. There are other cases where there are, say, a terrorism charge or a sedition charge, where the government says, well, we can't give all the information because that will go against the interest of the investigation of a national security. Are we seeing this kind of loopholes being created in this particular rule then?
No, again, I would not like to comment on a matter which is already sub judice before the Supreme Court.